I'd just like to mention that the next Saturday University will be held here in this very room on June 12th. The three people that will be here to talk at that time will be Jean Garrison, who's the director of the International Studies Program and an expert on China. Peter Parolin, who happens to be the chair of the Department of English, will come. And I don't know what he's going to talk about, but he's an expert on Shakespeare and all of that kind of fun stuff, and widely known for giving an exciting and entertaining lecture. And we'll have Rod Garnett, who is one of those fields with my favorite titles. He's an ethnomusicologist, and which means he's interested in non-Western forms of music. He's also interested in Western forms of music. He's an excellent flute player, but is interested in music from everywhere from Ireland through across Europe to Bali in Indonesia. And so he will come and talk to us and entertain us, I'm sure, with many little pieces in his talk. Our last, the remaining of today's activities, we'll first have a talk by Steve Easton, and then at 2:30 we'll have about a half an hour or 40 minutes of a roundtable discussion in which we'll have all three of our presenters up on stage, and you can pepper them with whatever kinds of questions you would like to. If you think there's connections between some of the talks and some of the topics that we haven't touched upon, we would be you'd be more than welcome to ask them and see if they can make those connections clearer to you. Okay, it's my pleasure to introduce Steve Easton, who's the dean at the University of Wyoming College of Law. He came to the university this summer after teaching law at the University of Missouri. Prior to entering academia, he worked as an attorney and a partner at a small firm in Bismarck, North Dakota for, a decade or more. And he's also served as the U.S. Attorney for the District of North Dakota. He has had extensive litigation experience and is authority on expert witnesses, cross-examination, and advocacy. Steve is one of those people that has moved from what we might call the real world, if law is real.
We'll get to that in a minute.
From the practice of law into the teaching of law, and as a trial lawyer, there's a lot of performance in the activity of being a trial lawyer, and so Steve has had to move back and forth at different points in his career to remain, a credible trial lawyer, trying his most recent trial in August, which he notes on the note that he gave to me that he won.
Not that anybody ever keeps track.
Steve, as an academic, Steve is the author of two different books. One is the book called Attacking Adverse Experts, and two, this is a sort of a self-help manual, How to Win Jury Trials, Building Credibility with Judges and Jurors. He enjoys spending time with his wife and their three children. He likes to cycle, golf, and is an avid sportsman. And I will note that when the Cowboys football team takes the field, he's no longer known as Dean. He takes on the name of Dad for his son Tedder. His plays for the Cowboys. So, Steve Easton, who will speak to us on theories of punishment. What is justice?
Thank you, Paul. This is actually my second educational mission to Jackson. I know what you're thinking. If he's been there before, why does he have a tie on this time? I'm evolving. The first time I wore a suit, this time I'm down to a tie, and by next time I'll fit right in. And it's really kind of ironic because I love to not wear a tie, but it's actually, Phil and I made a deal with each other. Since we both brought ties up here, we decided we would both wear them today. I want to tell you just a quick story about my last educational mission to Jackson. It was, in fact, the first week in July, the first week I was employed by the University of Wyoming. the former dean, transitioning, Jerry Parkinson, who some of you know, just a fabulous man, did wonderful things as dean at the College of Law. And I had a bit of an overlap period. And by the way, Jerry will be back on our faculty. He's on a sabbatical now, but he'll be back on our teaching faculty this fall. But Jerry had a speaking engagement at the science school, but not science related. It was for a program, a We the People program, a program for high school teachers about the Constitution and government in general, but the Constitution specifically. And so I said, Jerry, why don't I tag along with you? We'll drive across the state, and we can talk about the things that you want to talk about when you're taking over a job that someone's held for a long time. And then we got up here, and he was talking about the Fourth Amendment. He was talking specifically about the Fourth Amendment in school. The Fourth Amendment is the prohibition of unreasonable searches and seizures. So it's what protects your and my privacy and liberty interests. And then there was a very prominent case in the United States Supreme Court last term about a strip search of a student in a school who was suspected of having drugs. Some of you may be aware of that case. And that's what Jerry was going to talk about. And on the way up, he said, they might also be interested in Arizona versus Gant, another important case that came out in the last term of the United States Supreme Court that involves, broadly speaking, searches when vehicles are stopped on the side of the road. So I said, well, I could talk about Gant. And so Jerry gave me 10 minutes of his program, and it's a really neat program, the We the People program. And so we gave that presentation, and then we drove down to Kemmerer because he had something to give to his sister-in-law who lives in Kemmerer. And then we're driving across from Kemmerer toward Little America, where you get on Highway 80 again. And we're talking, talking about all these interesting issues, and I don't know, maybe some interesting faculty issue or something, and we lose all track of speed. And then we see in the rearview mirror lights in the back. And Jerry, it's an interesting transition from Jerry to me at the law school, because Jerry's an optimist. I'm a pessimist. I see the lights in the back in the rearview mirror, and I know what they're for, but Jerry says, I wonder who they're after. It quickly became clear who they were after, and so Jerry, we pulled over to the side of the road. So we're on the side of the road, and I'm looking in the rearview mirror. I'm in the passenger seat. I'm looking in the rearview mirror that's out, on the right side of the car, and I see the sheriff's deputy get out of the car, and he's going like this, and just making these big gestures. And now remember, I lived in Wyoming when I was 4 and 5 years old, but I haven't been in Wyoming in the 48 years in the interim very much. And I'm seeing this sheriff's deputy. I'm thinking, man, they take speeding really seriously around here. I thought, I've lived in Western states, I've lived in North Dakota, and speeding. I'm thinking they must take speeding a lot more seriously in Wyoming, because he is really ticked off. And then he's coming to my side of the car, because I guess that's the new safety thing, to come to the passenger side so that you're not exposing yourself to traffic. And I'm looking at it, and he's getting bigger and bigger as he's coming up in the mirror, and he's going like this. So, of course, I very respectfully and fearfully roll the window down, and he gets to the door, and he says, God, these mosquitoes are killing me out here. And that was a relief. That was a relief at that point. And so he indicates that Jerry had gotten into the numbers that I can't remember the exact number, but it didn't start with a 7. It started with at least an 8. And that he was going to issue a ticket, and so fine. And Jerry, they asked what we were doing, and Jerry said, well, we're from the law school, and we're driving back. He didn't mention that we've just given a presentation on these types of encounters, but so the sheriff's deputy takes his license and the registration from the rental car, which is a key fact we'll get to in a moment, and takes it back to the car. No big deal, okay, we're going to get a speeding ticket. Then another law enforcement officer comes up. They travel in pairs, you know. This is the highway patrolman who comes up with a German Shepherd, takes a look at us, and decides that it's worthwhile for him to spend his time having the German Shepherd take a trip around the car. Now, the fact I mentioned earlier is that we were in a rental car. It actually ends up being, when you travel on university business for a significant length, especially if you stay in the state, you actually cost the university less if you rent a car than if you pay mileage, than if you drive your own car and pay mileage. And so we were in a rental car with Colorado license plates on it. Now, I have to tell you about what's going through my head at this point. And again, it's based on personal history, so I hope you'll excuse me just a moment of personal history. I actually lived in Colorado 1 year growing up. When I was in 7th grade, my dad went to Boulder to finish up his doctorate. He got his doctorate when he was 42 or so. And so I lived in Boulder, Colorado in 1970. Now, my mind is flashing back at this moment to Boulder, Colorado in 1970. Boulder, Colorado was a wild place in 1970, I can assure you. And I'm sitting here in this Colorado car now saying, well, almost certainly somebody who rented this car before us was a doper. Let's just hope they got all of the dope out of the car. This is honestly what's running through my mind as this German Shepherd is taking this very slow trip around the outside of our car. And I'm watching very carefully, but trying not to look too suspicious. The German Shepherd makes it all the way around the car, not having indicated any interest whatsoever in the car. I think we're in pretty good shape now. At this point, the headlines that I had been seeing in my head, Doper Deans busted near Kemmerer, are now disappearing, and I'm thinking we're in pretty good shape. But after the highway patrolman gets around the car with the German Shepherd, he stops and he looks back at the two of us. I don't know which of the two of us caused this reaction, but he looked back at the two of us inside the car, and he kind of disgustingly looked down at the German Shepherd like, all right, Rover, we're going around again. Don't miss it this time. And he takes him around the car again. And I'm happy to report that he did not find anything of interest the second trip around the car. But that was my first trip as the dean of the University of Wyoming College of Law with Jerry Parkinson. And sometime later, I'll tell you about the second trip that I took as the dean on my first on my own. But let's get to the topic at hand. We're going to put on the table the topic of punishment. Not so much the topic of what should be a crime. That's a whole other. We could talk for days, and of course, legislators and Congress, people in Congress, debate that issue all the time. What should be a crime? We can talk about that as a related measure, but what we're going to focus on is what should we do, if anything, for those people who violate our criminal statutes. Why do we punish? Should we? In what circumstances should we? And we're going to talk on at least at the beginning on a relatively theoretical plane. But then, if you want, when we talk about questions, we can talk about some practicalities. Now, if this topic does not at first interest you, let me suggest to you that probably everyone in this room, or at least the vast majority of us, have at some point in our lives devised a punishment scheme. If you are a teacher who runs a classroom, if you are a Sunday school teacher who runs a classroom, and certainly if you are a parent, you have designed a punishment scheme. And implicitly, or maybe to a certain extent, even more openly, you thought about what you were trying to accomplish with that punishment scheme. If you're a sports fan, You're familiar with punishment schemes because you watch a sporting event, particularly some sporting events, and you see punishment schemes in action on almost a constant basis. Every time an official in a football game throws a yellow flag in the air, you have a punishment scheme, or an official in a basketball game blows a whistle and calls a foul. You have a punishment scheme in operation. We're going to focus on the criminal justice system and that particular punishment scheme, but the same sort of concepts apply to others. But let's put that focus on criminal punishment. And let me start out with, as lawyers tend to do, let me start out with a definition, the operational definition. I'm adopting from Joshua Dressler, a prominent criminal procedure professor. Professor Dressler, speaking basically for the profession, those of us who think about criminal justice issues in the context of legal education and in a wider sense, those of us who work in the criminal justice system, this is kind of a consensus definition. Someone is said to suffer punishment, as we're going to use that phrase for the next hour or so, if but only if some agent of the government, so it is punishment that is imposed by someone who is working for the government, or at least on behalf of the government, and is acting pursuant to a defendant's criminal conviction. And let me just make sure we understand what we mean by the term conviction. Conviction is not actually something that is done by a jury. When you see a newspaper report that says jury convicts Jones, only a lawyer would make this distinction, but that's not actually who convicts. The judge convicts. And the judge enters a criminal judgment, that is a disposal of the criminal case, a decision that is called judgment of conviction in most jurisdictions, and the judge will do that based upon any of the following absent problems that we're going to ignore for the moment that might prevent the judge from entering that conviction. So it could be based upon a jury verdict, if there was a jury trial and a jury verdict of guilty. It could be based upon what we often refer to as a bench trial or a non-jury trial. So the defendant, and in some jurisdictions, and the government have waived their right to a jury trial, and a judge is serving both as the decider of legal issues and as the decider of factual issues. And so the judge has made a finding that the defendant is guilty. But, especially in modern times, far more often it will be the result of a guilty plea, and in some jurisdictions, a plea not designated as a guilty plea, but where the defendant allows the entry of a conviction. In the federal system, it's called a nolo plea, where the defendant is saying, I'm not admitting I did it, but I'm admitting I'm going to lose, so I will allow you to enter a conviction against me. So any of those can be the source of conviction as we are using that term in this definition. And the agent of the government is intentionally inflicting pain or some other unpleasant consequence on the defendant by virtue of the authority of the criminal conviction. And so, I hope you'll excuse me if you use notes. I wanted to make a list of some things that are not, under this definition, punishment, and some things that are. These are some examples of things that look like they might be punishment. They're unpleasant, but they are not punishment as we use this term in the criminal justice system. For a civil damages verdict, if you sue because somebody ran you over in the sidewalk and the jury awards you $2.5 million and the judge puts that in a judgment, the defendant has to pay $2.5 million, but that is not punishment. That is compensation in the civil justice system. It's unpleasant. It's not usually desired. It's done by the government, but it doesn't result from a conviction. Condemnation of your property is unpleasant. When the government takes your property against your will, has to pay for it under the Fifth Amendment of the United States Constitution. It's unpleasant. It's done by the government, but not by virtue of a conviction. One that the very organized among us have reminded ourselves of this annual tradition. The rest of us will get to this in about 2 months. Paying taxes. Paying taxes is very unpleasant. It's the taking of your property. It is done by a government agent, but not pursuant to a conviction. Other unpleasantness, being drafted into military service and dying while in a place you do not choose to be as a result of being drafted into military service. It's unpleasant. It has very substantial consequences. It's not punishment. One that my son would add to this list would be mandatory school attendance. It is a removal of freedom from certain members of our society. We say you have to go to school, but it's not the result of a criminal conviction. Being ridiculed by a mob, or even being killed by a mob, even if they are doing it because they believe you committed a crime, is not punishment, because it's not done by an agent of the government, and it's not done as a result of a criminal conviction, even though the people that are doing it may be doing it because they think that you are ill. Being civilly committed because you are mentally ill and are a danger to yourselves or society. We're getting close to the line here, but it's not the result of a criminal conviction, and so would not be considered punishment under this definition. On the other hand, what are the classic things that are punishment? Paying a fine as a result of a criminal conviction. That's what happened after Jerry and I were on the side of the road in Kemmerer. There was a fine. Now, that was a result of, you might not think of a speeding ticket that results in, that actually does result in a criminal conviction. It's a relatively low level of crime, but that is punishment. Even, and it wasn't true in that set of facts, but even if you were fabulously wealthy and the fine was $25, if it is a criminal fine, that's punishment because it results from the criminal justice system and a conviction. A community service sentence, when as a result of your conviction you are required to perform certain services. Why is that considered unpleasant? It's a removal of your freedom. We're a liberty-loving society. When an agent of the government says you must do this, that is considered unpleasant under this definition and would be considered punishment. A jail term, even a very short one, that comes after your conviction is considered punishment, but not the time that you might have to spend in jail before you are convicted because you're not able to pay bail or whatever the conditions are that the judge sets. That's not considered punishment. Now, if you're sitting in jail, it's probably tough to tell the difference, but for these purposes, there is a difference. And obviously, the death penalty obviously meets this definition. Now, the one we're going to focus on today, and I want to show you a little bit of the real world, let a little bit of the real world sneak into this discussion, is incarceration. And before we get to our strictly theoretical discussion, I thought it would be helpful to remind ourselves of the facts of our current punishment scheme. The United States, and when I say the United States, I mean both the federal government and the states collectively rely very heavily upon incarceration as a punishment mechanism. By the way, most action on the criminal side is in state systems. Only in very limited circumstances, I say this as a former federal prosecutor, but federal courts, especially for criminal purposes, are courts of very limited jurisdiction, and there has to be a reason. We could get into a whole debate about that, about whether there's been too many federal crimes created in the last 20 or 30 years. But generally, crimes are prosecuted in state systems. I believe the number on felonies, I'm pretty confident the number is still above 90%, 95% of felony convictions are in state court as opposed to federal court. Now, I hope you will excuse me, and I will admit right from the start that in order to get some statistics together, in a busy job, I did what we all do these days. I went to Google and I found some stuff. And so understand that most of the things I found are by people that have an interest in these issues, and so keep that under advisement. And they seemed consistent with what I generally know about these things. Senator Jim Webb believes that there's too much incarceration under the federal system, and so that's the source of some of these slides. A few things to realize. The United States has 5% of the world's population, 25% of the incarcerated population. This flows from that, of course. We've got 5 times the average rate of incarceration of the entire planet. Ours is 5 times that rate. Some other manifestations of this, and I thank Professor Diane Corsell from our College of Law for these, because she lent me these slides. Beginning of 2008, relatively recent number, we got over 2.3 million people incarcerated on January 1st of 2008. That's a 600% increase, 600 plus percent. It's actually a little bit over 600% increase in our prison population since 1970. Looking at punishment more generally, one out of every 31 adults is under some sort of correctional sentence. County jail, prison, probation, parole. By the way, probation is also punishment. It's a restriction of freedom, and that is considered punishment if probation does come about as a result of a criminal sentence. Put these two figures together, and you realize that of those within this group, about a third of them are incarcerated. About 2/3 have other punishments at any given moment. Sometimes there's a combination. As a result of one conviction, you may be incarcerated at some point, and in some states on parole at another point. This is another way, again, from Jim Webb's office, U.S. Senator Jim Webb's office, of looking at starting in 1925, and looking at the number of people incarcerated has gone up dramatically since around 1970. This is an overall chart that I saw that purports to be based upon U.S. Bureau of Justice statistics, and it appears to be consistent with the other figures we've looked at. It's a little bit short of 2.3 million people incarcerated as of 2006. We have relatively steady numbers of persons incarcerated. I mean, it seems to go up. That seems to be the only direction it goes in, but it goes up relatively slowly for the period from 1920 to 1970. 1970 to 1980, it increases rather significantly, and from 1980 on, it increases quite substantially from that point forward. I thought we'd take a quick look at crime rate statistics, because when we talk about whether any of this does or does not make sense, I think it's helpful to have some information about crime rate statistics. Also, these graphs don't go back as far. They start in 1960. You'll see crime increasing, and this is a pattern you'll see over and over again. I've got several slides showing this. Crime increasing fairly dramatically from 1960 to 1980, goes down for the first half of the decade of the 80s, goes back up to 1991, so that 1991 is roughly equivalent to the 1980 crime rate, and it's gone down rather substantially since 1981. This is a graph of both violent crimes, the red one on the bottom, and property crimes. I shouldn't say nonviolent crimes. And property crimes in green, and then total in blue. Again, you see the same pattern. You see significant increases from 60 to 80. The dip in the mid-80s and going back up at about 1991, and fairly substantial decreases from 1991 to the last year for which we have data available, 2005. These are just, if you're going to get your graphs from the internet, you may as well get a few so you feel a little bit more confident that, and all the graphs show rather consistent patterns. You can look at, if you look at violent crime alone, you see the significant dips after 1991. See the same thing if you isolate non-fatal firearm violent crimes. I wanted to show this one as just one example. If we start looking at demographic characteristics of those who are convicted, if you start plotting age, now this is age plotted against homicides, and the pattern will show you that happily those under 14 commit very few homicides. Not zero, but relatively few homicides. Number goes up for the 14 to 17-year-olds. Highest number is 18 to 24-year-olds, 25 to 34-year-olds, and then fairly substantial decreases, 35 to 49 and 50 plus. When we get to rehabilitation, one of the most effective ways to rehabilitate a person is to age him. And I said him, and I know I should say him or her, but we're talking about crime here. And while there has been, ladies, you have made up a lot of territory on us in all sorts of places, but we are still kicking your ass on crime. We are way ahead. We are way ahead in crime. And so, while not all criminal defendants are males, that's the way to bet, and so I'm going to use the term he from now on, recognizing that it is. And by the way, that is not as true as it used to be. It is not as true as it used to be, but it's still, crime is still overwhelmingly a male phenomenon, although somewhat less so than it used to be. All right, let's talk about theories of punishment. And this, another reason this should be of interest to you is understand when these agents of the government inflict pain or other unpleasant consequences on people, they do it in your name. In your name. The criminal cases in the state of Wyoming carry the title State of Wyoming v. Jones. Am I right about that? I believe both New York and California, the title of a criminal case is The People v. Jones. In the federal system, the title of a criminal case is United States v. Jones. United States v. Jones. In fact, I remember the last day I was U.S. attorney. It's a great thing being U.S. attorney, but what happens is then they have an election, and then they have a new president, and you serve at the pleasure of the president. And if the wrong person wins the election, you no longer have the pleasure of the president. And so in relatively short order, you're out the door. And when that happened, and I gathered the staff of the U.S. Attorney's Office together, I told the assistant United States attorneys how jealous I was of them that they got to keep their job, and I lost mine. But then I said, I have now done for the last time the neatest thing, in my judgment, that any lawyer can ever do. And that is enter my appearance as U.S. attorney. Entering your appearance is a little mechanism that happens at the beginning of the trial. The judge, it's just kind of one of those formalisms. The judge says at the beginning of the trial, will you enter your appearance, and you stand up and you announce who you are and who you are representing. And when you're the United States attorney or an assistant United States attorney, you get to stand up in court and say, Your Honor, my name is Steve Easton, and I represent the United States of America. And I want to tell you, that is really cool. I mean, I have not done that for 18 years, and I still remember how cool that is. And I was saying, but what that means is, you are representing, in our system, a criminal case is brought on behalf of the state, the country, the people. Those prosecutors are doing it in your name. If there is a conviction, when you drive by the prison in Rollins, don't say to yourself, that has nothing to do with me. Oh, yes, it does. Those things that are happening in that prison are done in your name. Because we do not have a private justice system in our criminal system. We do have that in the civil system. But in our criminal system, the state or the federal government acts on our behalf. And so it is entirely legitimate for you to look at these issues and say, we got to change it. I mean, that's the glory of our democracy. None of this is set in stone. We don't have to keep incarcerating 2.3 million people. Or maybe you think we're not incarcerating enough people. And in our democracy, you can make your voice known, and that can change. If we are going to do that, though, inflict pain, what is the justification for doing that? Most of us have value systems that would say a human being should not generally, intentionally inflict pain, inflict suffering on another human being. And so if we are going to have our government do it on our behalf, there better be some justification for it. And we're going to talk about the two very different primary philosophical justifications for the infliction of that punishment. The first is known as, generally we talk about it as retributivism. Tough word to say. Computers don't like it. Apparently only lawyers and legal scholars use this term. This is the concept of just desert. Interesting debate about whether there should be one or two S's in that word, and you'll actually see it in this debate both ways. And I actually changed it. If you think about the other meanings of those two spellings, they both have some potential applicability to the criminal justice system. The idea here is that when someone violates society's rule, they deserve punishment. And that punishment is inflicted because the offender deserves it. In the federal system, where the prison system is run by the Department of Justice, this is at least, that seems to capture more of a retributive philosophy than others. We are putting you in jail or doing these other things because your activity makes you a person that not only should, a pure retributivist would say, not only should we, not only can we, not only do we have the right to punish you, but we have an obligation to punish you. Because by doing so, we are representing the goodness of our society. A pure retributivist will say, and I realize that we don't usually talk this way these days, but I'm just trying to put each of these theories in their starkest terms. A pure retributivist would say, we should hate the criminal. Because by hating the criminal, we are reinforcing the goodness of our society. And if we allow someone to violate rules to benefit from our social order, but not pay when violating our social rules, we have become complicit in that crime. And therefore we have an obligation. And remember, I'm stating this in the starkest of terms to show the contrast with the other philosophy. And there's by the way, the sort of, I guess you would say, the founder of this, or the first to articulate it in broad terms, is Immanuel Kant. And Immanuel Kant uses the example of a society. He talks about it as being an island. There's an island society. There is someone who has committed a murder. That person is incarcerated, awaiting execution in this island society. And for some reason, the society decides to disband. The volcano is going to, they get information, the volcano is going to blow, we're all going to go our separate ways. our society is no longer going to exist. Immanuel Kant says you have an obligation to execute that prisoner, because if you don't do so, you are all leaving the island with a little bit of his guilt on your hands as part of your soul. I mean, I realize very stark, and you know, there are very few people that I know that really take that idea that seriously, but that's the idea of pure retributivism. And that is why we are punishing you, to reinforce the goodness of our society, not to gain any other benefit from it. If we gain other benefits that the utilitarians like, a retributivist would say, that's nice, but that's not why we punish. We punish because the person deserves it. Notice then that the retributivist philosophy is very much focused on the past. In order to determine what is the just punishment, and in order to determine whether punishment is appropriate, we focus exclusively on the act, on what was done. And as we'll see when we shift to the other philosophy is very much focused on the future. Okay, let's shift to that, and then we'll kick it around at the end. Jeremy Bentham is the Immanuel Kant of the utilitarians. Jeremy Bentham is the founder, if you will, of utilitarianism, or prevention, to use a somewhat more modern term. The basic philosophy is that society should maximize happiness, which means it should minimize pain. Pain being the general opposite of happiness. And if society should maximize happiness, if that is the goal of society, to maximize the total amount of happiness, punishment, pain, is the opposite of happiness. And therefore, to a utilitarian, punishment can only be justified if, by inflicting 10 units of pain, society gains more than 10 units of some other benefit. And we'll talk about how society might gain those benefits in a moment. But notice that this is very much focused on the future, because the benefits from inflicting that pain will come in the future. And so one of the differences between the retributivist philosophy and the utilitarian philosophy is the time emphasis of the two philosophies. Utilitarianism very much focuses on the future. Okay, how do you do that? How can you inflict pain on one human being and thereby gain some sort of pain or gain some sort of benefit, for society? Well, it might be deterrence. By inflicting this pain, we are going to deter the possibility that this crime will be committed in the future. Now, that might be specific deterrence. We are going to punish the person who committed the crime so that that person, that particular person, will be less likely to commit the crime in the future. By the way, does that work? Parents, does that work? Sometimes, right? Sometimes. Or I don't know how many of you have multiple kids. I would say sometimes with some kids, with other kids almost never. It does. It can work. There's also general deterrence. We will punish this defendant who committed this crime so that the rest of us do not commit the crime in the future. We will observe this punishment and we will say, ooh, I don't want that happening to me, and therefore I will avoid doing what it was that caused this person to have this punishment done to them. Another benefit you might gain from punishing someone is rehabilitation. You use the punishment process to make that person less likely to commit a crime in the future by programs to try to retrain the person, by aging the person. It's really, it's probably the most effective way to do it is to age the person. It's not 100% effective by any means, but it's but you know, that will make the person less likely to commit the crime in the future. And there are others, but this is the final main one that people talk about, is incapacitation. We will put this person in a place where he can no longer commit this crime. By the way, if you put them in jail, that does not mean that they cannot commit crimes. Even if they don't escape, they can commit crimes in jail. But the incapacitation effect of an incarceration sentence is, yeah, but not to my family, as long as my family stays out of jail. Those are the basic possibilities. Then there are people that there are other things at the edges, but that's basically that is basically it. So let me put them up next to each other so that we're reminded of them, because this is a basic outline of the debate. And you might want to ask yourself, in your own punishment schemes, as a citizen of a state and a country that has a punishment scheme, what is it that you think we should be trying to do? I want to make a couple of notes about that before I open it up to questions and discussions. First of all, notice that not only is there a difference in emphasis in time, with the retributivists tending to emphasize the past and the utilitarians emphasizing the future. There are two very different views of punishment here. To a retributivist, in a sense, punishment is a good thing, because it is a reinforcement of our basic societal goodness. To a utilitarian, punishment itself is evil. It may be tolerable evil in some circumstances, but it is evil. Punishment reduces the happiness of a particular person, and so it has to be justified on some other grounds. A couple of other points. In our system, when I say our system, I mean the constitutional system in the United States, and the Constitution of the United States limits the activities not just of the federal government, but after the Civil War and the passage of the 14th Amendment, it also limits the activities of state governments. And under our constitutional scheme, there is no pure 100% utilitarianism, because our constitutional scheme requires someone to be convicted before they are eligible for these punishments. You know, if you want to incapacitate, this is on film, so maybe I shouldn't say this, as the parent of two teenagers, but if you want to really reduce the crime rate, I mean, I think some of us could agree that a very effective way to do that would be to incarcerate males from a certain age. You're going to incapacitate. Now, I'm not suggesting that way, but we aren't willing to do that. Even if we could prove that we could drive the crime rate way down, we are not willing to do that, because we are at least, even those who are serious utilitarians in our system have to be at least a little bit retributivist, because we are not willing to punish those who don't deserve it. And by the way, we don't even punish all of those who are, in fact, guilty of crimes. So we require not only actual, and by that I mean factual guilt, because our system requires the prosecutor to establish beyond a reasonable doubt that someone is guilty of crime. And under a system like that, there are some people who will escape punishment because, for various reasons, he said, as the U.S. attorney who managed to actually lose a bank robbery trial. You can't lose a bank robbery trial. But I did. My first trial as U.S. attorney. You know, there are some people who will escape punishment, even though factually they did it. And we do that because we have other things that we value in our system: freedom and limited governmental power. And under a system where law enforcement and prosecutors, and again, I've been there and I've done this, will sometimes, in order to be able to prosecute someone, will make a deal with someone else to allow them to escape punishment if they're willing to, my father finds this an absolutely abhorrent feature of the criminal justice system. I tended to agree with him, and then I became a prosecutor. And I made the realization that when bad things are happening, I would have loved to call Mother Teresa to the stand, but she was never there when there was a crime happening, and instead there were people who tended to be involved in criminal activity. So that's another reason why there are some people, and there are others, limited resources. Jerry Parkinson and I were far from the only people exceeding the speed limit in the state of Wyoming that day in July. But there's just a limited amount of resources that we devote to the criminal enterprise. So now, by the way, all of that is true of both of these philosophies. That's not just a limitation on utilitarianism. It's just a limitation on the criminal justice system in general. What about a person who the prosecutor can prove beyond a reasonable doubt that the person committed a crime, but there is none of these things to be gained? And we'd have to play with the crime is vehicular homicide, and in the accident that killed someone else, this person suffered some sort of injury, which means that they're not capable of committing at least that kind of crime in the future because of the very serious injury, very serious injury that they received. We'll take away general deterrence we'll say that we could pretend to punish them instead of actually punishing them. By the way, that's an important thing to keep in mind with regard to especially general deterrence. General deterrence depends not so much on what the punishment will be, but upon what the person making the decision about whether to commit the crime thinks that the punishment will be. And that is somewhat related to what the punishment will be, but not directly related to the punishment will be. We don't need rehabilitation, and the person's already incapacitated. Would we still punish that person? Well, it's at least a possibility under our system, which is another limitation on pure retributivism. And then the last thing I want to say before we get to a discussion, because I do want to throw it open for a discussion, the last thing I want to say about these two philosophies is there's a tendency these days to assume that the left side of the screen is a tougher punishment scheme than the right side of the screen. That retributivism will lead to longer prison sentences than utilitarianism. Not necessarily so. As I understand it, and I do not by any means claim to be a legal historian, but for a long time in England, our common law ancestry, a lot of our law is based on English law. A lot of our legal traditions are based on English legal traditions. And for a long time in England, if you committed the crime of murder, you were convicted of a felony and you were executed. And if you committed the crime of armed robbery, you were convicted of a felony and you were executed. And if you committed the crime of shooting a rabbit out of season, you were convicted of a felony and you were executed. I don't know about I'm making up the last example, but almost everything was a felony, and for many years in England, there was only one punishment available for felonies, and that was capital punishment. Now, that cannot be seen as a retributivist system because you are not targeting the punishment to the offense. Once you start asking yourself, what is it worth, you are on the left side of the screen. I mean, how bad was the crime? And if that should factor into the punishment, you're at least partially on the left side of the screen. That has to be seen as a combination of general deterrence and incapacitation. That's the only way you could defend a punishment mechanism like that. Now you may think to yourself, well, what about rehabilitation? Certainly rehabilitation is the least draconian of the goals of the system. Well, how about a shoplifter? A shoplifter with a problem. Convicted of a first-time offense, to take a not at all hypothetical example of a friend of mine, a first-time offense of stealing a $42 or so knife from a hunting goods store, a sporting goods store. Now, if you're going to have a retributivist system and ask what that crime is worth, how much debt he has to pay back to society, it's going to be a relatively, compared to other punishments, a relatively short prison sentence. But if you're going to rehabilitate him, and he has a significant problem, that could take years. You might have to incarcerate him for a long period of time to have any chance of successfully rehabilitating him. So there's nothing inherent, or maybe I should say absolutely inherent, in choosing the left or the right side of the screen as to saying whether or not you're going to have longer or shorter sentences, whether you're going to have less or more severe punishment. I'm done for now. Let's see if any thoughts or reactions. Yes.
I want to go back to the beginning.
Okay.
About punishment, and you had a variety of charts to show us rates of incarceration and changes in incarceration. I'm concerned about two things. Is what explanation do we have for the difference in incarceration rates between the United States and the average foreign country?
Okay.
And the other question I'll put out right now, so I don't have to stand up again, is what happened in 1970 and 1980 and 1990, etc.?
Yeah, I think they're related, but if I forget to answer both of them, remind me, because it will be unintentional. And by the way, I'm here. I really don't have a firm view of what the correct answers to these questions are, and so I'm going to try to answer your questions. And I'm not sure we've got the right punishment scheme, and so I mean I'm a participant in it as a prosecutor and as someone. So but I by no means do I think we have it correct or incorrect. I mean it's complicated. It's complicated. All right, how do you differentiate between the U.S. Incarceration rates? What could account for the differences? Here are some possibilities, and they're just possibilities, and whether they're legitimate differences or not. First, we have this is a society that does not have one common religion. It does not have a common culture in the traditional sense. I mean, we have a developing, constantly developing American culture, but we have is the term polyglot? Am I using? I mean, we come from everywhere, and we have lots of traditions. There are some other societies where some of the messages that are sent about what is acceptable and unacceptable behavior are sent by other, I'm not going to say universal, but almost universal value-enforcing systems, like religion, or a common culture in a more traditional sense than I'm talking about in our society. We ask the criminal law, in other words, what I'm saying is, I think we ask the criminal law to do more, in some sense, in our country than in some other countries. And I don't mean to exclude all other countries, but as a general comparison. Second, we are an individualistic, freedom-loving society. Our basic social order is, you can decide what you want to do, and we will, for the most part, or at least sort of, stay out of your way. When you wake up in the morning, you get to decide what you're going to do. You get to decide where you're going to travel. You get to decide what you're going to read. You get to decide what sort of works of art you are going to create. You get to decide pretty much everything. And we have a huge value in that. When we talk about being freedom, talk about our freedom and our independence, that's what we mean. The government doesn't tell us by and large, what to do. If you have government and other social mechanisms telling people what to do, as opposed to a society which says pretty much do what you want, I think almost by definition, you run a greater risk that some of the do what you want folks, in a sense, can't handle that freedom. And in a sense, and again, I don't know if any of these are, but these are just things things to think about. What happened in 1970? Let me show. I'm sorry. Let me answer that question quickly before I get to the next one. And I'm certainly other people have thoughts on this because there certainly have got to be some other explanations. What happened in 1970? Well, I was in Boulder, Colorado in 1970, and I'm serious about it. That's part of what happened. Part of what happened, to be somewhat trite about it, was 1968. 1968 happened. And 1968 brought to us the assassination of two beloved political figures, two, within a very short space of time. 1968 brought us the height of reaction to social order, but a response to that, a president, when you think about 1968, one of the crazy things, when you think of all the things that were happening in 1968, at the end we elected Richard Nixon, a law and order president. And that is very much the platform Richard Nixon ran on in 1968. Crime is very frequently a feature of political campaigns, but I think you can make an argument that no more than in 1968 was crime. If you go back and look at that election, Richard Nixon ran on a law and order platform. He said, things are getting too crazy, things are getting out of hand, elect me and I'm going to bring some order back. Well, how did he bring order back in? In large part by increasing the lengths of sentences and other things like wiretapping statutes and a whole bunch of other things. Wiretapping statutes have something to do with it because we started, and what else happened in 1970? You're at the end of the Earl Warren era, which was an expansion of our individual rights, and the pendulum has swung back a significant amount since then, so that prosecutors are winning more of those search and seizure and other cases. So prosecutors are given a few more tools than they were. Some of the things. What happened? When did the war on drugs start? Well, that term was actually invented by Richard Nixon. Most people say the real war on drugs started with Ronald Reagan and Just Say No and Nancy Reagan, but at least to a certain extent. But that's all consistent. That's all consistent with the charts. Another thing that happened in about 1987 was the adoption of the federal sentencing guideline system, which gave individual judges far less discretion, and a lot of states moved away from indeterminate sentencing. Indeterminate sentencing is when the judge at the time of conviction says your sentence is 20 to 30 years, but the real sentence is determined by the parole board at the back end. And the federal system moved away from that to a system where basically under federal law now, if you're given 20 years, you're going to serve 85% of that 20 years. And so there's far less parole. So a whole bunch of things happened. There was one. Let me get this one back here because someone had their hand up before. Yes.
I'm just wondering if you could comment with these sharp increases, the role and relationship between who's running these prisons and organizations such as like the CCA and privately run prisons.
That's another. Yep.
For the more beds that are filled, the more subsidies they're gaining.
Yeah, it's an interesting question. I mean, that's a very important point. I mean, another thing that has happened, maybe not in 1970, I don't know when, I don't know exactly when, the privatization, if you will, of incarceration started to happen, but that certainly has been a phenomenon of the last couple of decades. Pardon?
Particularly with detained immigration.
Yeah. I mean, it's. I don't. That's a good question. I don't know. Do you have a theory as to where that has an effect on?
I don't.
And I mean, I'm trying to think. I mean, I guess there is now assuming that if you run a prison, you get paid by prisoner days. Yeah. I don't know if that's true, but it seems like a reasonable assumption. Now we have someone with a financial interest in more prisoner days. So, I mean, I really don't know. Yes.
It goes back to the philosophical definition. Where does vengeance fit? Because vengeance is clearly an aspect of punishment.
Yes, it's interesting because the philosophers who debate this, nobody wants to quite claim vengeance, right? The utilitarians say that's a retributivist notion. You're doing it to get some payback, right? I mean, the utilitarians say that's a retributivist notion. It's an element of how you design justice. In fact, utilitarians will say to the retributivists, "You're just about vengeance. There's nothing else that it's about." Now, the retributivists would disagree with that. The retributivists would say, vengeance is not our deal. That's your deal. Because if we are punishing in part because there is an individual or group of individuals who suffered from a crime, we are punishing then in order to decrease the possibility that those individuals will seek their own vengeance. I'm not sure where it fits. I guess it might be considered an aspect of general deterrence. That we are saying, the retributors would say that, to the utilitarians, that if that's an element of punishment, we're doing it so people don't take their own. It's all part of the Lockean social contract, right? And that is our basic contract. That goes back to the absence of private criminal law. There was private criminal law for a while in England. If you were wronged, you sued the defendant. Now society sues on your behalf in order to avoid the possibility that people will seek their own vengeance. And by the way, that's another overlay over this whole process. Most of us are at least somewhat frustrated with the justice system in our country and the criminal justice system in our country. But we have to retain enough confidence in it that people will not, in large numbers, be seeking their own criminal justice system and will rely upon our societal criminal justice system. And by and large, that's true, although there's been some very tragic exceptions to that in American history, where people have gone outside the criminal justice system to seek their own vengeance. There was another question. Yes, sir.
Interestingly enough, in the last 2 weeks, NPR did a piece about people who came before the justice system for having done something extremely minor, some shoplifting in a small store or something. Mm-hmm. And they used to be released on their own recognizance. But now the laws were changed that they had to pay bail. And these were people that didn't have a quarter in their pocket. Mm-hmm. And they could not go to a bail bondsman because they had no assets to pledge. So they were being put in jail at a cost of $60 or $80 a day for a month or 2 or 3 because of the system. And it turned out that from a political point of view, it was the bail bondsman that maintained this particular statute and put their muscle behind it. And they acknowledged that of 100 people, only 10 or 5 would be able to get a bond because of having assets, and they didn't care about the other 90 that would be put into the system.
Yeah, I mean, if you are troubled by the incarceration rate slide, 2.3 million people incarcerated, we aren't even talking about those folks. Because we're talking about people who are incarcerated after a criminal conviction. What do we do before there is a determination, either from some sort of plea or a determination based upon a trial. That's a very complicated issue, too. By the way, like almost everything in our legal system, when you hear various platitudes, they aren't quite true. When we say in our system, you are innocent until proven guilty, we don't really fully believe that. Because if we fully believed that, we could not put any conditions on a person before they were found guilty. And there are people that, and so why do we do it? We do it as a recognition of the reality, at least a belief by many people, that if we didn't do it, there would never be an opportunity to determine guilt because people would flee and they would not show up for their trials. Because another feature of our criminal justice system is you're not tried in absentia in the United States. Not only can you not try a statue in our system, you can't try a dead person, and you can't try an absent person. At least on the first day of trial when it starts, the person has to be there, or there is no trial in our system. And so we even though we want to believe that you are innocent until proven guilty, you're not completely treated the same way as the rest of us. And bail is its own, we could have a long discussion about bail. There have been two federal bail reform statutes, both of them called the Bail Reform Statute. The first, I'm not going to try the dates because my dates are going to be way off, but the first was, and they only apply to federal cases. We're talking about federal statutes. There are some parallel legislation in state statutes, but now we're talking about something that does not apply to the states because this is procedural, not constitutional. And the first bail reform statute, in recognition of the concerns that you just listed, said way too many people are getting out on bail, way too many people are being held before trial in federal cases because of conditions that they cannot meet. And we got to quit doing that. And we got to start releasing more people on their own recognizance. And the federal system adopted that system for about 10 years. And then I want to say the 1984 bail reform statute came in and said way too many people are being released before trial with no conditions. They're committing all these crimes as they're awaiting trial. They're escaping. We got to put a lid on this. And the federal system now has lots of pretrial incarceration. And so, you face some of the same issues, but they're a little bit different. Yeah, I mean, I do think as someone who's lived some of my life in the criminal justice system, occasionally as a defendant, but more often as an attorney. And a defendant, they were all traffic ones, but as I say at the beginning of all my criminal law classes, I say one of the problems with talking about criminal law is we tend to think we're talking about the law for all the other people. No, we aren't. We're all criminals. Any one of you that has a driver's license that tells me you're not a criminal, yes, you are. Well, I mean, we're all criminals. There is no way you can be in complete compliance with the vehicle statutes. But if we're troubled by what we do to people after we at least have this system, imperfect though it is, it's not a bad system for requiring the prosecutor to prove guilt beyond a reasonable doubt. We really should be troubled by pretrial, but we do it as a recognition of something that we have to do. I've gone past my time, I bet.
One more minute, so time for
all right, let me
my question, in other countries where people of the age of 18 are asked to do some kind of military service, how does that seem to impact the rates of criminal activity between 18 and 24?
I don't know. That's interesting because that's another pretty substantial control mechanism. The way most militaries are run, we know from our recent history that it's not a perfect control mechanism, but it's a pretty substantial control mechanism. I will say this, and I started out with statistics and graphs. Always be careful of them. It's really troublesome when you start comparing crime statistics from one country to the other. Even when you compare U.S. statistics to Canadian statistics. Because what is counted, for example, as a violent offense is quite different in Canada. I can't remember exactly what the differences are. What is counted as a property offense? Now, incarceration is it's a relatively easy number to determine, the number of people that are incarcerated at any given point. But I have no idea, but I suspect that it helps. I suspect that it helps. Oh, I've got the local prosecutor. Well, we'll let you ask the question at the round table. That's all right.
Yes. We're going to take a 15-minute break, and then we'll come back. The whole time